Hello and welcome to Ellison Legals in case you missed it. We are now in September, so just going to go over August's posts. Couple of disclosures as usual. Ellison Legal has limited liability under a scheme approved by the Professional Standards legislation. And this video is not intended to give you legal advice, so please don't take it as legal advice. If you do need legal advice, please go see your legal practitioner so they can give you some advice that is tailored to your specific situation. So, just looking at the posts in August, we had 4 posts and they were all about preparing your will. So, wills, and even if you were going to consider something like a testamentary trust. So the first post was the importance of having a will, and it's important to be able to have your say, to be able to note down what it is that you want to happen to your estate. There are quite a lot of people who don't have wills, or they might have, say, DIY wills, homemade wills, the ones they purchase from the shops to just do themselves. And I'm all for freedom to do what you want, do as you please, but please bear in mind when you're not getting proper legal advice from practitioners who practice in this area day after day, who are up to date with case law and legislation and things like that. Those are the wills, those DIYs, that sometimes get caught out with issues. So I do encourage, if you are going to get a will drawn up, your first will, an updated will, whatever the case may be, please go see a legal practitioner who does wills pretty much day in, day out. So the second post was about distributing your assets, how you want that to happen. Is it just going to be a general distribution to your beneficiaries? I give the whole of my estate, or after payment of debts, I give the rest and residue of my estate. How is it that you want your estate to be distributed? Are there specific items that you want to give to a specific person? Stamp collections or war medals, or I don't know, the precious car or something like that. Just bear in mind, when you do give away a specific bequest in your will, if it is an item that you have disposed of during your lifetime that is no longer in your will, this can cause issues. Often I see clients coming to me and saying, this is my homemade will, and it says, I give my house at 5 Alphabet Street in Sydney to Joe Bloggs, my son Joe Bloggs. And if that house has been disposed of, that can cause issues for Joe Bloggs, who very well may potentially not receive the gift at all. So there are certain rules around that. So when I see this in some wills, some clients don't, they're not aware of the problems of being so specific. Sometimes we think being specific is better. Sometimes there are issues along with being specific. So unless, again, using that word, we specifically want that asset to go to a particular person, we do try to avoid it. But yeah, specific bequests are something that we can put into wills. The third post was about super or insurance, or even certain properties, different types of assets that you might want to dispose of. So the reason we mentioned this third post was because sometimes we have an interest in property an interest in an asset that we often think is our property, but it's not actually our, asset. It's not our asset. So when we talk about, say, superannuation, that's not our asset. We have an interest in that asset. We are a beneficiary of a trust of those superannuation funds. We don't have ownership over that. The trustee of the superannuation fund does. It's the same thing with insurance policies as well. You got to think, is it something held by a trust or a fund? When that happens, you may be aware with your superannuation, you make binding nominations or non-binding nominations. And you do that because you are telling the trustee what you want to happen with that asset. Why are you telling someone if it's yours? Because it's not yours. It's the trustee's responsibility to do what they're either instructed to do or what they think is best when they don't have an instruction on what to do. So assets like that do not automatically form part of your will. You can do things to allow it to fall into your will, but at first instance, they do not form part of your will. Something else is an example like, say, property. If you have purchased property with, say, your spouse, you may have purchased it as what we call joint tenants, not tenants in common. So again, this goes back to property posts or videos that I've already done and probably will do again. But if you are a joint tenant with someone, basically what that means is that upon your death, that it's not really a share, but that share in the property goes then to the remaining joint tenant or joint tenants. It will not form part of your will. So there are different assets to consider. Again, another good reason why to speak with a legal practitioner who is across all this and understands how all these things work. And then the fourth post was about estate distribution, and where you have say significant assets or complex family dynamics, like a blended family. We did this post just to draw your attention to what we call testamentary trusts. It's something to consider by creating by having a will creating a testamentary trust allows certain assets to be given to certain beneficiaries in certain ways in order to protect those beneficiaries. There's also benefits for, say, taxes, where you can have tax minimisation, not tax avoidance, and certainly not tax evasion, but yes, definitely tax minimisation. So when it comes to testamentary trusts, we do like to work with your financial person to make sure that what we are proposing legally falls in line with what your financial person wants to happen financially. And that goes both for significant assets and blended families. There might be other situations. There might be a person you're trying to protect, young minors. It could be someone who doesn't know how to deal with money properly. It might be someone, an adult who is a dependent and needs assistance with things like that. But there's also, with the significant assets, is the monetary component is, even though testamentary trusts while a will creating a testamentary trust can be quite costly, and it is. And it is for a reason, because it's quite a complicated document. At the end of the day, it can really, really save dollars if it's done properly. So upon a person's death, it can really save quite a lot for your estate, for your beneficiaries. So that's something else to think about. So those were our 4 posts, and we will go over September's posts in October. So thank you for joining me tonight, and take care. Bye.